Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar on this sweltering day, where we're going to talk about basics of the right to know law. Let me go over a couple preliminaries here before we dive into the actual subject matter. If you haven't sat through one of these webinars before, it's basically a PowerPoint presentation with me talking in the background. The PowerPoints are available on our website. And I know this question will come up again, but you go over to the training tab and scroll down and you'll be able to find all of the PowerPoints that we use for our trainings here at the Office of Open Records. You're welcome to use any of them as you see fit. Excuse me. Maybe you have a colleague or a coworker who couldn't make it this morning, so you can refer them to the PowerPoint. You can use it for your own training locally or your own future reference, whatever works out for you. This session is being recorded, and the recordings as well will be available for you to use. Typically what happens is a couple days after this, the administrative staff will load the webinar onto our YouTube channel, and then a link is established to the website, and you can usually find it on the website at, let's say, a week or so afterwards. If you'd like a copy of the recording, you can contact the office and they will set up permissions for you to be able to go in and have the link. And I think that's how you access it last time I checked. So, again, all of the recent videos for the different topics that we have webinars on would be available. Just reach out to the office and they can set you up. As far as questions go, use the chat feature while we're going through the presentation, and I will do my best to answer your questions live. Recently, with some new technology that we have here, sometimes the questions on the chat aren't showing up immediately, but I'll make a point to go through them and scroll through them and try and make sure I don't miss any. Two conditions on these questions. First is, we're talking about the right to know law, so let's stay on topic. And more importantly is that I would ask that you keep your questions as succinct and on point as possible, brief. Reason being, occasionally people will type out several paragraphs, and it's just awkward for everybody when I'm sitting here reading through it while they're waiting patiently, and then, it usually takes an extended answer. So we'll do one of two things if that's the case. If it looks like your question is unusually complex or maybe specific to your particular situation, we'll wait until the end and I'll come back to it and try to get you steered in the right direction. Or we'll take the conversation offline. The contact information for the office is on the screen right now. Any of you, please feel free to reach out to our office whenever necessary. What will happen is whether you call or send us an email, first it goes to the administrative staff, and they are very well versed on the right to know law and can usually get your problem solved for you. If you happen to stump them with, like I said, an unusual set of circumstances, your question will get escalated up to one of the senior staff, and they will do their best to get back to you within 24 hours. Honestly, that's our standard, but things lately have just been incredibly busy. We are breaking records every month for volume of appeals that are coming in through the door, as well as right to know requests that come in. So, excuse me, I would ask for your patience with them getting back to you, but it is a priority for us to respond to your request because we figure it's important and it's time sensitive. So we do our best to be as responsive as possible. But, given conditions lately, it's a lot harder. Okay, sip of coffee here. Yeah, and let's dive in, okay? Let's talk about why the right to know law is important. And, it's pretty basic here. It's public access to government information, what nowadays is called government transparency, all resulting in good or better government from our perspective. I like to begin the presentation with a basic fundamental statement about what the right to know law is, because there's a lot of misunderstanding. People see that term right to know and they interpret it as some form of government Google where they can seek any sort of information, they can ask any sort of questions, and it's government's job to run around and find the answers. And that's just not the case. That's not what the right to know law is. The purpose of Pennsylvania's right to know law is to give the public access to public records. No more, no less, okay? I submit a right to know request. I give it to a government agency for government records. And then the determination is made whether or not what I'm asking for are public records. And if they are, then they're provided to me. We still get people who think that they can get, corporate records, personal records, all kinds of stuff through the right to know law, and that's just not the case. Let me repeat. Is to give public access to public records, all right? And what I recommend to right to know officers or open records officers, those two terms are interchangeable, is that occasionally you will get a request or find yourself in a situation where you're just not sure which way to go. You're just not sure what decisions need to be made. Go back to this fundamental statement. A lot of times it will get you pointed in the right direction and determine what your next step should be. Now, all of that being said, let's take a look at the starting point. And it is that every record in the possession of an agency, and when I use the term agency, I'm talking about state cabinet level departments, commissions, boards, and the like, local government. It could be cities, townships, boroughs, school districts, as an extension of school districts, public charter schools, authorities, any entity created by statute. For the most part, falls under the jurisdiction of the right to know law, and we refer to them as agencies. But every record in the possession of an agency is presumed to be public. That's where you start from. Now, if you get a request for a record and a red flag goes up, and it's like, I don't know, I'm just not comfortable with the idea of releasing this information, this record, chances are that there is a tool, either in the right to know law or another law, that would support your uncomfortableness, your anxiety, and allow you to legally withhold that record. But you need to keep in mind that it is the agency that bears the legal burden of proving that a record is not public. Okay, it's not just a matter of going with your gut feeling and saying, okay, we're going to withhold this because I just don't like the idea of releasing it. Rather, the right to know law requires that you make a legal case as to why that record should not be released. Now, that sounds very daunting. People hear this for the first time, or maybe they get their first right to know request and they start looking at the law and they think, oh my gosh, everything in the office is going to end up on the front page of the paper tomorrow or on somebody's Facebook page or whatever. And I can tell you that's not the case. And I'll explain that as we're going through this presentation to make you aware of all the tools that are available to agencies. And if you're joining us from the public side, the requester side of the equation this morning, I think you'll understand why these records should be kept private, because they could entail personal information about you or citizens like you that you would not want released into the public domain. Okay, so this is the fundamental caveat, the fundamental, what I'll call the foundation of the right to know law and what it's based on. Okay, let's move on. It's important to note that the right to know law is not a confidentiality law. Okay, what does that mean? Well, let me explain. First off, Ann, there's nothing in the right to know law that prevents an agency from simply giving out public records. You're not required to use the right to know law to give out public records. Let's say it's budget season, and within the office, you've got a stack of budgets. I come into your office, I ask for a copy of the budget. You can simply hand me a copy of the budget, and you have not violated the right to know law. As a matter of fact, if I would have a right to know request asking for a copy of the budget, and you've got a stack of them there, you could say, George, you know what? If you tear up that right to know request, I'll simply hand you a copy of the budget. It will save you a lot of time, and it will save me a lot of paperwork. And from my perspective, why wouldn't I do that? I'm getting what I'm asking for, and you're saving yourselves a lot of time and trouble. Now, I could say, no, I want to follow the right to know process. Then you would have to do that. But then I could end up waiting like up to 35 days before I even get a response as to whether or not you're going to give me the budget. So, like I said, there's absolutely nothing in the right to know law that prevents you from simply giving out a record. The other thing that I want to stress is that we're going to be talking about something called an exemption, which exists within the right to know law. We need to keep in mind that those exemptions are discretionary. Those exemptions do not say you must withhold the record. Under the right to know law, they say you can withhold the record, which means you can give them out even though an exemption exists. Okay, but I'll explain all that further on into the presentation. There's nothing that says an agency must require a right to know form in order to honor a right to know request. I could walk in and verbally say, this is a right to know request, I'd like a copy of the budget, and you can treat it as such. Just keep in mind that you can't, that a requester cannot appeal a verbal right to know request. Also, I could walk in with my request simply written on a piece of paper, not an actual form. And you could choose, the agency could choose whether or not to honor that request or not. An agency can require that you use a form, but it's not mandatory that a form be used. For instance, believe it or not, the Office of Open Records has accepted right to know requests written on the back of napkins. Okay. Not for a while, but I was here when it happened. Okay. One of the things that we recommend is for agencies to be proactive with your open records program. And what I mean by that is take a look at your right to know requests and identify trends. What are people asking for? And then rather wait for the next right to know request to come through, go ahead and put those records like on your website or other social media platforms that you might have. Such things as budgets, contracts, salary information, purchasing documents, all that stuff that people typically are looking for, put it on your website. And that way, next time you get a right to know request for one of those records, your response can be, that's on our website, here's the link. And the right to know law considers that a valid legal response. Okay, and two things will happen. The hits on your website will start going up, and right to know requests will start going down. So a little bit of work at the beginning saves you a lot of work over the long haul. And from my perspective, that's a good thing. Use your websites as business platforms because this is what the public expects nowadays. They'd much rather sit in the comfort of their family room on their laptop, be able to search your website to get the information that they need, than the alternative, which potentially would be take an afternoon off from work, come down to the Borough Hall, file a right to know request, and potentially wait up to 35 days before they even get a response. as to whether they're going to get those records or not. Okay, be proactive, be customer friendly, put those records on your website that are public anyway. That will work for the betterment of everybody involved. Okay? So your agency is subject to the right to know law. There are some things you have to do. Most importantly is you have to appoint an agency open records officer, what we call an ARO. This is the same as a right to know officer. There's no difference. Okay, this is the person who's responsible for receiving, processing, and responding to right to know requests. It's an important role. An agency can have more than one right to know officer, as long as it's clear to the public, who do I give this right to know request to? There's also no requirement on where the right to know officer or the ARO exists within the organization. It could be the mayor, it could be the chairperson of borough council, it could be a nice lady you meet when at the front desk when you walk through the doors to the office. There's no limit on who it can be, other than it needs to be either a public employee or a public official. Oh my, look at this response. Someone wasn't listening to me earlier. Okay, measures, tools, the OR utilize to prevent the broad application of exemptions by agencies. Okay, I'm going to have to come back to that. This question is a little long. Okay, an agency can also come up with its own rules for administering its open records program. And as long as those rules aren't in conflict with the right to know law or any rules promulgated by the Office of Open Records. Let me give you a quick example. For instance, the right to know law says that an agency may accept anonymous requests. Well, in Pennsylvania, we have another law called the Statutory Construction Act, which tells us that because that word may is in there, it also means may not. Okay, so an agency could pass a rule or adopt a policy that says we will only accept right to know requests where the person is identifying themselves. Okay, and the right to know law has several examples like this where it allows a great degree of flexibility for agencies in how they administer their open records programs. An agency can also come up with its own form. Many do. They like to have their seal at the top, contact information for the open records officer, maybe any of those rules that they have locally, but you also must accept the state form, or what's called the uniform request form. All right, this is on our website. There's nothing particular special about it. Many agencies like to link to it, and they can do that. Finally, we also ask that you let us know who your AROs are. On our website, we have a searchable database. A lot of people use it to find out who to send right to know requests to, but we recognize, people move on, they retire, they get promoted, they go to different agencies or whatever, and the database needs to be kept up to date. This is also who we reach out to when we get an appeal. So one of the takeaways from today might be to check your information on our website. If it's not up to date, there's a form there that you can fill out, send us. We will verify it and then update the database. Okay, let's take a look at this question here. Broad application of exemptions. In my experience, there are instances where the OR appears to accept agency affidavits without thorough scrutiny. Okay, I think I understand your question, Adrian. I'm not sure I have an answer that you're going to like, but the courts have determined that everything that's placed before an appeals officer from an agency, because they bear the legal burden, has to be supported by an affidavit or an attestation. This is a form where the agency says, this is what we believe to be the truth. we sign this under penalty of perjury, and then the ARO or the appropriate employee signs the affidavit. Okay, the courts have determined that this is sufficient for an agency to meet their legal burden of proof. The Office of Open Records has no authority barring what would appear to be a blatant mistruth of investigating the veracity of those attestations or those affidavits. Okay, we have to take them at face value. If they would be inaccurate or untrue, you are correct in that then the requester would bear the burden of proving to a court that in fact perjury has taken place. It's the role of the Office of Open Records to determine whether or not records are public or not. If it's believed that an agency is lying, we do have the limited ability to issue a finding of bad faith, but we don't have either the tools or the legal authority to investigate whether or not those affidavits are in fact true or not. The requester, if they believe the agency is not being forthright, would be able to take that affidavit, which is considered part of the record of the appeal, which is all public, and go to a court and say, this is untrue, here's the basis for me believing that, and then a judge would decide whether or not, in fact, perjury has taken place. Okay, I know that's probably not the answer you would like to hear, but that's where things exist as far as the jurisdiction of the Office of Open Records. Okay, let's dive into the next slide here, where we're still talking about agency obligations, and it would be the postings. Okay, on your bulletin boards or on your websites, provided you have a website, you would post the following information, and it's all intended to educate the requester. Okay, you need the contact information for the ARO. Again, answer the question, who do I give this right to know request to? Then contact information for the applicable appeals office, because if you deny the request, the requester has rights to appeal. Now, in 95%, if not more, of the cases, if you're denying a request, the appeal would go to the Office of Open Records. I recommend you simply put down the URL for our website, because you can file appeals online and it feeds right into our docketing system. That's, the easiest way to file an appeal. Then you need a form for the request, because I may not have one, you may not have one available on your website or whatever, but if you do have a website, it's got to be there. Also in your office, that if I want to file a right to know request and you require a form, you need to be able to give me a blank form. Help me out here. And then again, you need to post any of those local regulations, policies, or procedures that you put in place, like the example of the anonymous requests, okay? Let the person know what the playing field looks like before I enter the game, okay? Because people hate surprises. They hate these hurdles, these roadblocks that are put in front of them unexpectedly. So the more you can educate me as to how your right to know process works, the easier it's going to be for me, the easier it's going to be for you, and the happier the result is going to be, okay, in the long run. Educate the requester. Okay, there are some things that an agency cannot do relative to the right to know law. The first is that we cannot limit the number of records or the number of requests that a person submits within a specified time frame. You can't say, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. If she's inclined to file a dozen requests this week, the law allows her to do that. Okay, you also cannot compel a person to tell you why they are filing a right to know request. You can't deny a request based on the reason or what you think that reason is. Occasionally, People will file right to know requests just to see you work harder. It doesn't happen a lot, but we acknowledge those people are out there. There are things you can do, okay, when you have a problem requester. And it's usually a result of the relationship between the agency and that person breaking down some way. I would recommend that you sit in on our webinar that deals with the payment side of the right to know law, because we'll be talking about that briefly today, but we do an entire webinar on the right to know process and the payment side of it. And I think that goes far into helping how to deal with what we call problem requesters. Okay, moving on. Let me make sure we haven't missed any questions here. Yeah, we're good. Okay, I like to describe the right to know process as an obstacle course. You've got the start, when we're receiving a request. You've got deadlines built into the law that are similar to time standards. I don't know how familiar you are with the Olympics. I'm kind of a sports geek when it comes to Olympics and world championships and that kind of stuff. And for many of these entrants, the reason we don't have like 180 entrants, one from every country, is that they establish time standards. In order to make it to the Olympics, even though you're the best in your country, you have to meet a certain time standard. You have to come below a certain threshold in order to qualify for a berth at the Olympics. Okay, very similar with the deadlines built into this obstacle course. Then on the course itself, you have 2 hurdles. And in front of the second hurdle, there are 3 hoops that we have to go through. Only when you make it over the second hurdle are we saying, this is a public record and we're going to grant your request. All right, so let's dive into the obstacle course to get an understanding of what we're dealing here with this process. Receiving the request, the start. Well, it's important because of the dates built in to the right to know law, that when an arrow receives the request, they note the date that they receive it. Because the first deadline that kicks in is that an agency has 5 of its business days to provide an initial response. All right, let's get into this a little bit. If I receive a request today, and today's a business day, and let's say tomorrow's a business day also, my first business day is tomorrow. Okay, that's when the clock starts ticking. And then I have 5 full business days in which to provide an initial response. Now, we say it's your business days because not all agencies are on a Monday through Friday schedule. It is not uncommon to go up into like the northern tier of Pennsylvania, and you may only find an office that's open 2 days a week. Okay, so using that example, let's say the 2 days would be Wednesday and Thursday. Okay, so I received the request today. Tomorrow's my first business day, Wednesday, Thursday. Then I go to the second week, Wednesday, Thursday. Then I go to the third week, Wednesday. And Wednesday would be the close of business Wednesday would be my 5th business day. All right, that's when the initial response is due. Okay, so that's why it's important, your business days. You would then maintain a copy of the request. Now, this gets a little complicated here, but I think there's a simple answer in the long run. Under the right to know law, it says you maintain a copy of the request for 30 days or until all appeals have been exhausted. Now, if you've got appeals, they can go up to 2 years. They can go all the way up to, well, even longer than 2 days or 2 years, because it can get appealed all the way up to the Pennsylvania Supreme Court, and that can take a while. Okay, but if the appeals have been exhausted or the person's chosen not to appeal, under the right to know law, 30 days. But in Pennsylvania, we also have another law called the Pennsylvania Municipal Records Act. It applies to boroughs and second-class townships. I also think first-class townships and perhaps counties. I would have to verify that. There's no equivalent for school districts on records retention, but essentially what the Pennsylvania Municipal Records Act says that for right-to-know materials, hold on to everything for 2 years. I think that's a good general rule that should work out for you, okay? Hold on to all your right-to-know materials for 2 years. After that, you can shred them, dispose of them, do what you have to, and you probably won't have any issues there. Okay, questions popped up. Does the start of the 5 business days start when the request is submitted or when the arrow first puts eyes on it? Great question. Legally, and the case is Donahue versus the Office of the Governor, the clock starts ticking when the right-to-know request is received by the arrow. Okay, and this applies to most situations. There may be some unusual exceptions that would exist, but let's say your arrow is on vacation and a right-to-know request comes in. Well, the clock doesn't start ticking legally until the arrow is back from vacation. Now, if that's the case, what I strongly recommend is that you have some sort of out-of-office reply or another employee who can reach out to the requester to let them know that the arrow is out of the office, they'll be back next Monday or whatever, and that's when the deadlines will the timeframes will fall into place here. That way, everybody's on the same page as to when the deadlines are, because it can be important with filing appeals and your responses and so forth. But good question, Eugene. And like I said, if you want to read more about it, you can find this case on our website. It's Donahue versus the Office of the Governor. Okay, moving on. Extensions. Let's say, for whatever reason, that the agency is unable to provide a final response during the 5 business days. The right-to-know law allows the agency to take a 30 calendar day extension, and it's unilateral. You don't need the requester's permission to do this, but it's 30 calendar days, which is different from a business day. A business day would not include Saturday, Sunday. A business day would not include a holiday. For instance, tomorrow, state offices are closed for the Juneteenth holiday, which is why we're doing this webinar today and not normally on a Wednesday. So that would not be considered a business day. Emergency weather closing would not be considered a business day. But a calendar day is different. You pull out your calendar and you count 30 days, all of the days. And when it falls on the 30th day, close of business that day, is the end of the extension. But in order for the extension to be valid, some conditions need to be met. First, the extension needs to be invoked within the original 5 business day window. You can't wait until what would otherwise be the 6th business day and say, oh, I forgot about this right-to-know request. Well, I'm just going to take an extension. Unfortunately, what has occurred is that you have denied the request by default. Legally, it's what we call a deemed denial, okay? And you don't want to do that. You want to respond, or you want to invoke your extension within the 5 business day window. You need to notify the requester in writing. And if the request came in by email, responding by email is perfectly suitable. Then you need to provide a reason why you're taking the extension. And if you go to section 902 of the law, it lists 6 reasons. It could be we keep these records off site. It's going to take us longer than 5 days to go through them and figure out what's public and what's not. Or we want our solicitor to review the response to make sure we're not giving out anything we're not supposed to. All stuff like that that makes sense. You choose the reasons that are applicable in your case, and that's what you use to notify the requester. Then you provide a date as to when they can expect to get the response. Usually the agency puts in the 30th day. An estimate of any costs that the requester can expect to incur. It's just an estimate. It's not a hard quote. you settle up when it comes time for the actual provision of the records. Okay, so you've got the 5 business days with the 30 calendar days tacked on to the end of it. 35 days, if you will. Another sip of coffee here. Okay, so now we're up to the first hurdle. And here, the question needs to be answered. Is it a record? Okay, seems fairly basic, but let's get into this a little bit. Whenever I'm trying to understand a law, okay, and researching it, I always go to the definition section, okay, and the right to know law is no different. You go to the definition section, and sure enough, you find a definition of what a record is. And I'll just paraphrase here. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, let's translate this into English. What does this mean? Highlighted. Documents a transaction or activity of an agency? Well, it means that the requested record is about what the agency does. Okay, it's congruent with the mission of that agency. It represents the business that that agency does. All right, well, you're thinking, why wouldn't a record in the possession of an agency be reflective of what the agency does? Well, let's say I'm an employee and I send an email to one of my colleagues. I hear a new restaurant's opened up downtown. Do you want to meet for lunch tomorrow? Or what do you think of the trades that the Eagles are making and how it's going to affect their season this fall? Or I'm picking up a pizza on the way home tonight. All right, all fairly common communications that you would find in any office setting, but yet none of those examples rise to the definition of a record. Thus, if someone were to submit a right to know request for my emails, those 3 examples would not be considered responsive. They wouldn't make it over the hurdle because they do not rise to the definition of a public record, of a record under the right to know law. Okay, so I don't have to worry about that sort of communication being released through the right to know process. Along with this, though, I want to make it clear that, let's say I'm at home in my family room on my personal computer, on my Gmail account, and I send an email to Nathan Byerly, the Deputy Executive Director of the Office of Open Records. It says, hey, Nate, I'm preparing a webinar on affidavits. And could you send me some examples of affidavits that appeals officers have used in questioning their accuracy? Okay. And I send that off. Okay. Even though I'm at home on my home computer on my personal Gmail account, the content of that email clearly documents a transaction or activity of the Office of Open Records. Okay, one of the very first court decisions related to the right to know law was that I cannot use personal devices and personal accounts to hide the public's business. Okay, now there's nothing illegal about what I'm doing. And I could, pull out my cell phone and text as well. But it is the content of that message that determines whether or not it's a record, not how the message is sent. Now, between you and me, I would recommend against using your cell phone for business purposes, okay? But there's nothing preventing you from doing that, okay? It's not illegal, it's not unethical, doesn't violate the right to know law. You just need to be aware that those messages, even though they're on your personal device, are still discoverable under the right to know law. Just keep that in mind. Okay, moving on. Now we're up to the second hurdle. But remember, before we can go over the hurdle, we have to jump through 3 hoops. The first hoop, we have to answer the question, do any exemptions apply? And if so, are we going to invoke them? All right, what's an exemption? Well, you go to section 708B of the Right to Know Law. And by the way, you can find the Right to Know Law on our website, on the main page. You can download it for free. It's not a long law, and it's not hard to understand. There is legalese in it, but for the most part, it's written in common English. So you go to section 708B, and you're going to find 30 exemptions. An exemption is a definition of a record that the agency can withhold from public release at its discretion. Okay, it represents a very broad scope of records. And when you look at them, they're all things that I think we could all agree, well, yeah, you wouldn't want to release something like this into the public domain. For instance, section 708B1, it basically says that if by releasing this record, we would put someone in harm's way, you can withhold it. There's another one that says if releasing this record would jeopardize the security of your computer systems, you can withhold it. There's another one that deals with public employee health records, okay? You wouldn't release that, okay? And for instance, there's another one that says if by releasing these records, we would divulge information about a minor, okay? You don't give it out, okay? You can withhold them if you want to. All right, so that would be the first hurdle, or I'm sorry, the first hoop. If any of those exemptions apply and the agency chooses to invoke them, you don't make it through the first hoop. You're off the course, okay? You've been disqualified. Then we come up on the second hoop. And here we have to answer the question, are there any federal, state statutes or a judge's order that make these records non-public? Okay, now this is important because there are any number of other laws that an agency can use to withhold a public record because those laws say these records are confidential. A couple quick examples here. School districts usually refer to a law called FERPA, the Family Educational Rights and Privacy Act, which make it illegal to release any individual educational records. Okay, it's not that they choose not to, it's that the law says they aren't allowed to. And if they do, there's typically some sort of sanction involved. You have the alphabet soup of federal health laws, HIPAA, FERPA, ADA, all the others that make it illegal to release personal health records, okay? So the agency would not be able to do that. And again, there are sanctions. Okay, Eugene, all right, well, I'll say it again. Refer to Donahue versus the Office of the Governor. It is basically that the clock starts ticking when the right to know request is received by the agency open records officer. Okay, back to topic here. So these laws basically remove the discretion that an agency has to give out something, okay? The right to know law gives the agency discretion. These other laws say, no, you may not give these out, usually under penalty of some sort of sanction. Another question has popped up here. What if the exemption claim is made, but the record is not really an exemption? Well, then it can be appealed, Adrian. And we'll talk about appeals towards the end of the presentation. Okay? Then we have the third hoop. Is the record protected by privilege? And here we're talking usually about attorney-client privilege. This protects any communication between a lawyer and their client where you're dealing with sensitive information. In our particular example, we'd be talking about a solicitor and the elected officials or senior management of the agency. Okay, in any emails, any reports, any letters or whatever that go back and forth, typically are protected by attorney-client privilege. And you can refer to Section 305 of the Right to Know law that provides that legal basis, where if it is protected by privilege, it must be withheld, because attorney-client privilege is part of the rules of evidence in Pennsylvania, supported by statute and referred to in Section 305 of the law, and they would be withheld under attorney-client privilege. Okay, let's move on. Oh, and I want to make it clear, go back here. If you've made it through the 3 hoops, you can now jump over that second hurdle, because you're saying that this is a public record. We're going to grant your request. We're going to release your the records that you've requested. All right, but you see the challenges that we need to go through before we get to that point. Okay, now let's talk briefly about payment issues like I promised. And here's an important one. The agency is only required to provide the record in its current medium. Okay, what does that mean? Well, that it's hard copy versus electronic. An agency, if they only, for instance, if they only have the records in hard copy, then they're not required to scan them in to provide them electronically because of Section 701, okay? You're not required to scan records in if you don't already have them in electronic medium based on this language in Section 701. I'll give you a quick example. Let's say we're talking about building permits, and this is an entirely paper-driven process. I submit my application with forms and plans and so forth that I give to the township. Okay, they have a codes officer who reviews the plans. Any correspondence that goes back and forth is in the form of letters and sent snail mail. And then finally, they issue an approved permit to me, which is a piece of paper that I have to put in my front window so that all my neighbors know the work that's being done has been approved by the township. All right, now a right to know request comes in for a copy of the approved permit, but it's a piece of paper. Okay, there's no electronic version of that. And the request is asking for an electronic copy. Why did they do that? Well, because it's easy and there's no charge for electronic records. But because the agency doesn't have an electronic copy, they're not obligated to scan it in order to make an electronic copy. Rather, their response would be, we have this record, but it's hard copy. We're happy to make you a copy of it, but we're going to charge you up to 25 cents a page. So the requester would have to then request a hard copy and pay for it. Okay, that's how that works. And like I said, if it is electronic, the agency cannot charge for the electronic records. There's also the option of inspection. And there's 2 ways to submit a right to know request or to request records. The first is for copies, like what we've been talking about. The second is the person actually wants to come into the office and inspect the originals. Okay? They can do that, but the agency's in the driver's seat. They decide when, during normal business hours, it's convenient for you to come in and inspect the records. And they can supervise the inspection to make sure nothing is altered, stolen, destroyed, or whatever. Okay? But the requester is also allowed to bring along, their cell phone camera and take pictures of the public records. They're allowed to do that. You can actually bring in a copier if you want as long as it's not disruptive to office operations. Okay. An agency cannot charge for labor. They cannot charge for redactions. They cannot charge for any sort of legal review. That's simply considered the cost of doing business. An agency can only charge for what are called pass-through costs or actual costs. Postage would be a good example, where if you have a postage meter, you can document how much it costs to mail out these records to the requester. So we're going to add the postage cost to whatever invoice we send out with the request for records or with the grant letter. Okay. Questions popped up from April. Do copies of police reports apply? No, they do not. Okay. There is a court decision from the Pennsylvania Commonwealth Court that says police reports, or what are known as police incident reports, are inherently investigative. Thus, exemption 708B16, which involves criminal investigatory records, can be used by an agency to withhold a police report. Okay. If you would want to sit in on our webinar dealing with right to know in law enforcement, I explain that a little more in detail, but that's pretty much what you're up against there. A police department can release an incident report at their discretion, but understand, April, that the law, and this case law, allows a police department to withhold the release of an incident report, even if that incident report is about you. Okay, it's considered confidential. All right, moving on. Just getting into payment issues a little bit more. No surprises. Okay, there should be, when necessary, a conversation between the requester and the agency that clears up any potential misunderstanding. All right, there's nothing in the right to know law that prevents a requester and an agency from talking to each other. And you got the phone, you got email, take care of any problems before they become really big problems. Now, under the right to know law, it's, ideally it's a mutual exchange. Here's the payment, here's the records. But the way the law reads is that records are provided upon payment. That means the agency gets the check first, and then they can release the records. Okay. And an agency can wait for the check to clear before they release the records. Now, here's another important point about what's often misunderstood about the right to know law. All these deadlines I've been talking about, they apply to the date of the response, not the date the records are released. Okay? Understand that. The deadlines are the response, not the provision of the actual records. So I've got 5 business days to provide an initial response. That response might be, I'm granting your request. Send me your check for the cost of these records. And when your check clears the bank, then we'll release the records to you. We'll mail them to you, or however. Okay. That's how the process works. But it's up to an agency as to whether they want to wait or just send you the records along with the bill. Okay. It's, again, the right to know law gives the agency the discretion in how they manage the whole payment system and invoicing and so forth. The law also allows an agency to require prepayment if it looks like the response is going to exceed $100. I like to refer to this as like a security deposit. Okay. So if they get a really big request and it looks like it's going to cost more than $100, they can say, send us a check for the full amount up front, and then we'll begin processing your response so that we don't get stiffed with making all these copies and doing all this work, and then you never pay us for it. Okay, that's why I refer to it as a security deposit. And then there's another provision in there that, let's say we grant the request and there's an agreement with the requester that they're going to come into the office and pay for it, and then we'll release the records to them. Well, what if they never show up? The right to know law allows 60 days, okay? If the agency has met its obligations, 60 days from the date of the response. If the person doesn't show up, then after 60 days, you can discard those records, all right? Because like I said, the agency met its obligation. It's not the agency's fault if the person doesn't show up within 2 months to pick up the records. However, if there was a cost involved, and let's just use $30 as an example, that cost does not go away, okay? Because like I said, the agency did everything it was supposed to do. Now, what if on the 61st day, that person shows up? Well, they're out of luck, okay? The records are gone, and they would have to file another right to know request in order to get those records. But before they can even do that, they need to pay the $30 for the first request. And chances are there's going to be another $30 for the second request. What if the person doesn't even want the original records anymore, but they submit a right to know request for a completely new set of records? They're not going to get anything until that $30 debt is settled up. As long as there is an outstanding debt on their, we'll call it account, the agency does not have to process any further right to know requests. And this debt doesn't go away. There's no statute of limitations, okay? It doesn't go away after a month, year, 5 years, whatever. But bear in mind that it is considered a denial. You are denying based on non-payment. A denial can be appealed. So make sure all your I's are dotted and your T's are crossed before you send out that denial letter. Because if it gets appealed, the appeals officer is going to want all of the documentation that shows how you calculated the debt, all the communication that took place between the requester and the agency, and so forth. Now, if everything's in order, chances are the appeals officer will support your denial, okay? But just bear that in mind. Okay, some questions has popped up here. Is there a webinar for right to know requests relating to request proposals for public bids? No, not a specific webinar. Much of what goes into bidding, the whole bid proposal, is driven by various codes depending on where that process is taking place. School districts, you'll find it in the school code. Boroughs, you may find it in the borough code. Townships, the same, okay? Bottom line is, in the right to know law, most information can be withheld until the contract is let, and then information, depending on the nature of the information, once the contract is signed, then that information can be released. But again, I say that, take that with a grain of salt, because there may be proprietary information that was included in the bid proposals that can be withheld. It just depends on what it is. You look at it on a case-by-case basis, and then depending on the case and the various codes that apply, you look at it on a record-by-record basis. Proprietary information would not be released, and practically no information would be released before the contract is actually signed. Okay, now next question. Can the request for payment be on a case-by-case basis, or must it be applied across the board when the policy is established by the agency? That's a good question. Well, they're all good questions for the most part, but in this particular case, the right to know law is silent on any sort of invoicing process in the payment. However, I would recommend that you apply it uniformly, not different for one requester from the next, because you could find yourself in hot water, not so much the right to know law, but in, how you treat one member of the public versus another. And that could end up actually getting in a federal court. Okay, jets. Is there a limit to the number of extensions an agency can file? Well, yes, the law only allows one 30 calendar day extension. Now, you can go beyond that, and we've done this here at our office. Let's say that it's a big request, all right, and it's going to take us, in some instances over 100 man hours to put together all these records that we are granting. Well, that's not a good example to use. Let's just say it's going to take longer than 30 days for whatever. Through a mutual agreement, and it has to be signed, an agency can go beyond the 30 days. All right, if it looks like the end of your 30 days is coming up, okay, the agency would reach out to the requester and say, hey, it's going to take us longer than 30 days. Here are the reasons. If the requester agrees, you come up with a short agreement in writing. So if things go south, you have that available. If the requester disagrees, then the agency's out of luck, okay? And the person can appeal when that 30 calendar day deadline lapses, okay? But to answer your question, there can be extensions beyond the 30 days as long as everybody's in agreement. The first 30 days is unilateral. Anything beyond that, you need agreement, okay? And that's in there. It's in the provision right beyond the one for extensions, which, well, let me think here. That's 905. So I think it's section like 905B or 906, something like that, where you would find the actual language for that. Okay, moving on. Denying access. Let's say that the person didn't make it through the obstacle course. So we've got to provide them with a response that denies access to the records they requested. There's a format for a denial letter. Here it is. The first is you provide a description of the records that have been requested. Why would you do that? Well, sometimes it's not altogether clear what the person's asking for. They're not an attorney, but they play one on TV and they write this request that, may not make sense. So you put it in your own words. This is what we think you're asking for. Okay, then you provide the legal and factual grounds for the denial. Why aren't these records public? Remember at the beginning where we talked about how it's the agency's legal burden to show why these records are not public? Well, this is where the rubber hits the road. Usually, you refer to the appropriate exemption within the right to know law. And you make the nexus between these are the records you're requesting, they're investigatory in nature, so we're applying 708B16, which allows us to withhold investigatory records. Okay, and that would be, for our purposes, meeting your legal burden. Then you put in the name, title, signature, and address for the arrow, okay, the contact information, because remember, this is the person legally responsible for responding to the request. The date of the response, this is important because another deadline kicks in when you send this response, and then the procedure to file the appeal. In most cases, it's going to be with the Office of Open Records. And that is 15 business days, Office of Open Records business days now, that they have to file an appeal with our office. We recommend for contact information, simply putting down our website for the reasons I explained. You can file an appeal online. That's the easiest way to do it. All right, so what happens when an appeal is filed? Well, we look for 4 elements. We need a copy of the original request, a copy of the agency response, provided there was one. Then the person needs to provide us with a statement about why they think the records are public, and they need to address the grounds as to why they think the agency's denial is incorrect. And those final 2, that's fairly easy to do. They're basically checkboxes during the appeal process. I'm told it takes about 20 minutes to file an appeal online with us. Now, if any of these elements are missing, we will issue what's called a deficiency order. And that gives the person like 2 or 3 days to correct the deficiency. If they fail to do that, we will dismiss the appeal. However, if they do satisfy the deficiency, then the case gets docketed. Okay? When a case gets docketed, a couple things happen. First, a number gets assigned to the case, and it would be something like AP 2024- and a 4-digit code. It gets assigned to an appeals officer who is the attorney acting as a judge during the appeal process. Then we send out notices. The same thing gets sent to the requester and the open records officer for the agency. And it is basically an email or a paper packet, depending on the circumstances, that includes the instructions, that includes some forms that need to be filled out. It's primarily for the benefit of the agency, because an appeal is a legal action taken against the agency for their failure to release the requested records. Okay, now, if you are joining us today and you're from an agency, if you happen to be an agency open records officer, and you get one of these notifications of an appeal, here's the most important advice that you'll get today. Run, do not walk to your solicitor and notify them that you have an active appeal before the Pennsylvania Office of Open Records. Everything I've described up to this point has been what I will say is an administrative action. When an appeal is filed before the Office of Open Records, we are a court. Okay, the Pennsylvania Supreme Court has defined us as an independent quasi-judicial tribunal, meaning we are a court. Okay, so they require us to act a certain way, thus we must require agencies to respond in a certain way. You have to use certain forms, you have to use certain language, certain legalese and so forth, and your solicitor is expected to know how to do that. They're the point person during an appeal. Okay, the open records officer is not expected to do that. Please do not attempt to respond to an appeal by yourself. Earlier, we were talking about affidavits. Here's a good example. Let's say that the response to the right to know request was, we don't have the record you're asking for, okay? That's acceptable. But the person, for whatever reason, doesn't believe you. So they file an appeal. Okay, now it would be just as easy to send us a response here at the Office of Open Records. We don't have those records. Unfortunately, that's not good enough. Remember what I said, anything filed before the Office of Open Records because of our status as a court needs to be supported with an affidavit. And it would look something like, I am the agency open records officer for XYZ Township. I'm the person responsible for all of our records. I know where they're at, I know what we have. And I have conducted a good faith search for these particular records, and I am telling you we do not have them, and I sign this under penalty of perjury. And then you sign, the lawyer would have you sign and date it, and then they would submit that as part of the evidence in meeting their legal burden before the Office of Open Records. Okay, that kind of explains what an affidavit is and what Adrian was asking about earlier. So that would be how you meet your legal burden during the appeal process. Simply telling us that you don't have the record isn't good enough. Okay, so that kind of explains why your solicitor needs to be involved. So please do that. Do not risk losing an appeal based on a procedural error. We hate when that happens. Okay, so the product of an appeal is what's called a final determination. This is the ruling issued by our office. It carries the weight of law, and it looks just like a decision you would see coming out of your County Court of Common Pleas or the Pennsylvania Commonwealth Court or wherever. Okay, same exact format, same findings of fact, same legal basis for whatever decisions are made and the like. Okay, we have 30 days to issue them. Occasionally we'll ask for an extension. When we do that, please agree to it. You can also find these decisions on the legal websites, LexisNexis and the like. I'm sorry, I hit the wrong button. Okay, there is the option of mediation that you may want to take a look at. This is where the parties actually get to speak to one another during the appeal process. Everybody has to agree to it. If mediation fails, it goes back to the regular process. But it may be a quick way to resolve any potential disagreements that you have, and everybody's happy as a result. Just, it's an option available to you. Okay, our decisions can be appealed to a higher level court. If it's a local agency, it goes to the county court of common pleas. If it's a state agency, it goes to the Pennsylvania Commonwealth Court. It has to take place within 30 days of us issuing our decision. We will do one of three things. We'll just monitor the case. We may submit briefs to educate the judge as to how the process works and so forth. Or if it's an important legal issue, we may actually ask for an appearance before the court. Okay. But remember that the Office of Open Records is not a party to the dispute. The dispute is still between the requester and the agency. If either one disagrees with our decision, they take it to the higher level court. You do have to notify us that you're doing so, but the dispute is still between the two original parties. Okay, and that pretty much wraps it up. If you have any questions, now is the time to get them in before I log off. But in the meantime, I want to thank you again for your time here today. Good series of questions. But in the meantime, let's talk about the website. Okay, you've heard me reference it several times during this presentation. That's because it is simply the best government website you will ever encounter. Okay, it is updated 6 days a week with new decisions that we've made, with court decisions, any information about government transparency in general. You can look to our website for that information. Can an agency charge a copy fee for scanning of paper docs to an electronic copy? Well, Dorothy, if you were listening, number one, the agency is not required to scan records in, because that would be converting from one medium to another. Okay, so that's the first thing. But let's say they go ahead and scan the record in. Well, what's the result of scanning? It's an electronic copy. And an agency cannot charge for an electronic record. So at the very basic level, they cannot charge you for scanning. Now, there may be an exception, and that is where there is a sensitive piece of data that they have to redact from the original record. They're saying it is a public record, but let's say there's a social security number on it. So we have to black that out, and we don't have what's called redaction software. So they would print the record out, black out the social security number, and then scan the record back in. They could charge you for that piece of paper that they had to print out in order to redact the social security number. Okay, that's the exception. Okay, and it happens occasionally. But, it's a good question, but the basic answer is an agency cannot charge for electronic records. But when it comes to scanning, chances are they don't have to scan it in the first place. Can an agency who does not have redaction software charge a requester for that software? No, they can't say we need to go out and buy it, so we're going to charge you for it. No, they can't do that. Can you briefly describe FOIA Buddy emails coming into my Burrow emails? Yeah. FOIA Buddy is a software package that's been developed It is legitimate, okay? These are not scamming emails or viruses or anything. So it is out there. However, there is some misinformation with their website. For instance, they're saying that the Office of Open Records can issue fines and that the fines can be collected by the requesters. That's not accurate. The Office of Open Records, while there's a $1,500 fee in the right to, or a fine element in the right to know law, only a judge can issue those fines, not the Office of Open Records. And if the judge does fine an agency, the requester doesn't get that money. Okay, that kind of goes back into government. All right. So, you know, people, their eyes are going to be open when they discover this. All right. Then there's also the issue, like what I was talking about, anonymous requests. So if you're getting FOIA buddy requests, you might want to take a look at what your policy is for anonymous requests and whether you honor them or not. Okay. We do have a bulletin on our website involving FOIA Buddy, and we have had discussions with the creators, the owners of FOIA Buddy. My guess is that it's going to go away before too long when people really get a close look at how it works. But in the meantime, it is legit, and we do have appeals based on FOIA Buddy before our office, okay, active appeals. So take a look at that. All right, Dorothy, you're welcome. As a new employee, what is the best first step to becoming the Borough Arrow? Well, April, get some training, okay? And congrats for you to be here and showing that initiative. I would suggest that you also sit through the webinar on payment issues, and that you also take a look at the webinar we do on laws that protect information. I think that these are the big three for a new open records officer. Other than that, you know, take a look at the law itself, take a look at the training resources. On our website, we have the Open Records Officer Guidebook. 78 pages you can download for free. And that will also provide you with a lot of good information. Take a look at the videos that we have on our website. And then finally, if you encounter a situation where you just don't know what to do, call us, okay? Or send an email. Say, help, you know. We can't write requests for you. We can't write your responses. And we can't discuss any active appeals or give you legal advice. But we certainly can get you steered in the right direction. And hopefully that will help you out. Other than that, you know, I think it's basically going to be get some experience under your belt. And you'll get it, okay? It's not rocket science per se. So much of the problems encountered under the right to know law are where people simply aren't doing their research. It's what I call intellectual laziness, where it's easier just to say, you know, response denied, rather than taking a couple minutes and figuring out what's the person asking for and what does the law say about our ability to release this information. Okay, you do a little bit of research and usually you're on good footing. I can say, having worked in this role for close to 10 years now, that the best open records officers are the ones that do a little bit of research. And there are some crackerjack open records officers out there who I just, you know, it's been a pleasure working with them over the years because they really know their stuff. And I think, okay, what if they have other duties that they do? I would want to live in that jurisdiction just based on the quality of employees that they have. So go the extra mile, learn about the law, gain some experience in what you're doing. And I think those will be excellent first steps. And hats off to you for at least asking what you should be doing. Okay, I think we're going to wrap things up here. Let me just check, make sure that nothing's come up. No, no more questions. Okay, Again, thank you for your participation today. Those of you who may have off tomorrow for the Juneteenth holiday, I hope you enjoy it. Everybody stay cool, okay? If you're working and you're in a jurisdiction, maybe you have a cooling center or for whatever, good for you. I think people are going to need it, just given what we're facing. So I'll be back again in 2 weeks and look forward to seeing many of you then. But we're going to sign off now. Take care, folks. Stay cool.